Good day everyone, welcome to another episode in our What If series. We will bring you insights in the format of a what if question on the ever-evolving landscape of employment law. I am Ross Simon from Maserumule, and in today's episode we shall unpack what if an employee who has secured a permanent position with one employer subsequently takes up a concurrent permanent position with another. What are the applicable legal considerations and implications? This issue was decided by the Labour Court in the matter of Vilakazi vs CCMA and others. As we always do, let us start by setting out the background and the facts of the matter. Dr. Vilakazi, the employee, was initially employed by the University of Witwatersrand, her employer, as a part-time lecturer effective the 1st of August 2017. At the same time, Dr. Vilakazi was also employed by Alexander Forbes. She declared her employment with Alexander Forbes to the university, and the university was nevertheless prepared to employ her on that basis. Almost 1 year later, during May 2018, Dr. Vilakazi resigned from Alexander Forbes and took up full-time employment with the university as a lecturer, effective the 1st of July 2018. In terms of her contract of employment with the university, her package was nearly 800,000 Rand per annum. In terms of her contract, she agreed to familiarize herself with all policies, rules and regulations applicable to the university's permanent academic staff. The university's declaration of interest policy required that any involvement in any external institutional affairs, including moonlighting, had to be approved by the Vice-Chancellor's office. Soon after Dr. Vilakazi taking up her full-time employment with the university, she took up full-time employment with Kantar South Africa Proprietary Limited as an accounts director. Dr. Vilakazi was to earn a monthly salary which was around 36,000 Rand more than what she was earning at the university. In terms of her contract of employment with Kantar, Dr. Vilakazi agreed not to be directly or indirectly interested in any business of any kind whatsoever without Kantar's prior written permission. Dr. Vilakazi even agreed to a restraint of trade. Therefore, on the facts, Dr. Vilakazi first took up full-time employment with the university and committed herself to the university. She then turned around and almost immediately took up full-time employment with Kantar and equally committed herself to Kantar. Dr. Vilakazi did not disclose to the university her intention to take up employment with Kantar and did not obtain prior written approval as required by the Declaration of Interest Policy. Once the university discovered the state of affairs, Dr. Vilakazi was subjected to a disciplinary hearing where she was charged with gross misconduct in that she took up full-time employment at Kantar South Africa Proprietary Limited whilst still in the full-time employment of the university without the knowledge or authority of the university. Your conduct was to the prejudice or potential prejudice of the university. Vilakazi was found guilty of misconduct as a consequence of her employment with Kantar and was subsequently dismissed. Dr. Vilakazi challenged the fairness of her dismissal in the Labour Court. At the Labour Court, Dr. Vilakazi argued her dismissal was unfair because she had no obligation to report her employment with the university until February 2019. By virtue of the university's declaration policy. She contended by virtue of this clause, she had until the 28th of February 2019 to declare her employment with Kantar. Until that date, she had no obligation to declare it. Furthermore, she argued her dismissal was unfair because she could manage the two positions and she did not think it would prejudice the university. And lastly, she saw no conflict of interest. The Labour Court rejected Dr. Vilakazi's first argument that she was under no obligation to report her employment with Kantar to the university until the end of February 2019 and preferred the employer's evidence that in terms of its policy, which Vilakazi clearly ignored, provided that in the event of a material change in association of a member of staff, a revised declaration must be submitted within 30 days. The court accordingly found that the employment with Kantar was a material change in association which required an immediate amended declaration, which Dr. Vilakazi failed to provide. In addressing Vilakazi's argument that she could manage the two positions, the court too preferred the evidence of the employer that the work of a full-time academic at the university, such as the position she had been employed in, required full-time focus and carried with it a substantial amount of work. The court accepted the employer's reasoning that full-time employment with Cantor would have the risk of directly impacting on her duties at the university. The Labour Court remarked that Dr. Vilakazi would need to show superhuman abilities to just discharge her obligations under both contracts, which was not humanly possible. Accordingly, the Labour Court furthermore found that objectively a conflict of interest, or at least a very real risk of a conflict of interest to the prejudice or potential prejudice of the university existed. Finally, the Labour Court found that the fact that Dr. Vilakazi was paid more at Cantor than at the university placed her loyalties towards the university in question. Should there be a case where both employers require specific work to be performed at the same time? Accordingly, the Labour Court found that a conflict of interest would prejudice the university existed. The Labour Court found that what was done by Vilakazi is moonlighting and is contrary to what the policy requires. The Labour Court found that Dr. Vilakazi's dismissal was fair. Accordingly, the Labour Court held that moonlighting as a matter of principle is unacceptable. The court reaffirmed the consequences of moonlighting for employees, that moonlighting without prior approval constitutes a breach of fiduciary duties and undermines the employer's prerogative to make informed decisions. It shall remain the sole prerogative of the employer to decide whether to allow this to take place and furthermore on what terms it may be allowed. Employers are to uphold their duty of good faith towards their employers and to disclose any conflict of interest. Accordingly, a failure to disclose and obtain consent will be a breach of the duty of good faith to your employer, and dismissal might be justified. That brings us to an end of this week's episode. Thank you for joining us. We hope you have found our discussion informative. If you have any questions or comments, we'd love to hear from you. You can find us on social media, or you can email me at ross@massconsulting.co.za. Until next time, bye-bye.